SJC-12702, Commonwealth versus Keith Williams.
Okay, Attorney Shaw, whenever you're ready.
Chief Justice Budd, and may it please the court, my name is Robert Shaw. I'm privileged to appear today on behalf of Keith Williams. Facts matter. Keith Williams was not with Jordan Reed's group of five as they entered the market from the direction of Charlotte Street. He was not present for nor aware of tension inside involving Colas and Teven. He did not participate in an exchange of words outside that lasted seconds. In fact, he wasn't identified by a single witness as having been in the vicinity of the market. What the evidence in this case shows is that after a very brief exchange of words, Reed's group turned their backs and walked away toward McClellan Street. There is no evidence they engaged, no evidence they provoked, they walked away. The only evidence before this court is that 6 seconds after they walked away, Colas returned, followed with Teven, and within seconds pulled out and pointed a firearm as if in the process of shooting to kill. And that sequence, walking away, Colas's conduct, then there was a scream, then shots, negates the gun battle narrative. This record is devoid of any evidence.
Well, how does that negate it? A narrative of a gun battle? One person raises his arm with a gun as though to shoot the other group, and the other person in the other group shoots back. That sounds pretty much like a gun battle to me.
That sounds like self-defense. That sounds like a defensive reaction. The record in this case is devoid of any evidence that the person who did fire prepared, planned, provoked, joined in a fray, or brought a gun in response to an altercation. And for those reasons, it doesn't reflect a consensual gun battle, which is really what the Commonwealth is ultimately trying to assert. Now, what is so disturbing about this case is the government having manufactured Williams' motive based on tension inside of a store that he could have had no awareness of, asserting the logical impossibility of an agreement between Colas and Williams to harm each other that they may not have known about, and baselessly labeling Colas and Williams as sworn enemies, despite conceding that Colas caused the shooter to fire by imminent life-threatening conduct. Quote, but for what he did that day, referring to Colas, she would be alive. But for him pulling out and causing Keith Williams to shoot, she would have been alive. Those are the prosecutor's words in opening statement at volume 9, page 58. Now, on the issue of deliberate premeditation, the evidence simply doesn't support it. Colas was the pursuer. Colas was the aggressor. The only evidence we have in this case is of a reactive, defensive response caused by Colas's life-threatening, sudden and inexplicable conduct. There's no evidence of a duel. There's no evidence of a face-off. There's no evidence of simultaneously choosing to engage in a gunfight. And even the nature of the shooting itself, off balance, leaning against people on a fence, wild, inaccurate shooting, indicates a frenzied, adrenaline-fueled, unplanned, panicked response, a factor that was acknowledged in reducing a murder conviction under 33E in the Lattimore case. And in the Lattimore case, there wasn't any imminent harm coming from the victim. Why would anybody abruptly, as you'll note in this case, be jumping up and down screaming, as Ms. Robinson testified, if this was planned and premeditated? It makes no sense. It indicates that that person was suddenly alerting others to what was happening as they were walking away.
I take it that you're arguing the sufficiency of the evidence. You're at this point.
Deliberate premeditation, yes.
Right. So, as you know, we have to take the evidence in the light most favorable to the Commonwealth in assessing that argument. And we also are required to take into account the reasonable inferences to be drawn from the evidence. I understand and take your point, which relies, well, your recitation of the evidence so far has relied on the direct evidence, not necessarily on the reasonable inferences, which of course we need to do. I usually find it more helpful when people are arguing sufficiency to try to take the facts. I know it's hard in your position, but to take the facts in the prism through which we have to take the facts. Otherwise, I'm just going to end up arguing all the reasonable inferences that I think the evidence may support. So what I see here is that your client was seen shooting the gun, that ultimately, this is the evidence in the light most favorable to the government. They're seen shooting the gun that ultimately killed one person and wounded another. The evidence appears to me to show that he did that after Colas raised his arm with a gun. Certainly might have suggested that it was in self-defense, but there was no self-defense theory forwarded or pressed at trial. And that was because your client took the position that, anyway, just hold on. That evidence was not, that theory was not pressed. It's true that the defendant was not with, or at least no one saw the defendant with his two companions before the shooting. But it's also true that those two companions hadn't been engaged in a altercation, conflict, some kind of interaction, hostile interaction. At least the jurors could conclude that there had been a hostile interaction of some sort in the store. The defendant had been seen in that neighborhood 45 minutes earlier.
Your Honor, I don't mean to interrupt, but you're reciting a lot of facts that I disagree with. And
right, but I'm just trying to say, if you're going to argue the sufficiency of the evidence, it's to me at least, it's helpful if you do that, taking the lens on the facts that we are required to do.
Right, Your Honor, but the reality is that inferences have to rest on proven facts and a foundation of evidence. You can't stack inferences upon inferences. And that's what this case consists of. It consists of stacking inference upon inference upon inference. And you can see that by my addressing these foundational facts, which do not support these foundational inferences that they want to make. And because they can't support those foundational inferences, what we have is a situation, going back to sufficiency of the evidence and deliberate premeditation, that the government is relegated, as reflected in their brief, asserting that the mere fact of being able to fire is evidence of deliberate premeditation. That's what their position is in their brief, ultimately. And that extraordinary assertion would mean that anyone who reacts to avoid imminent harm, whether a police officer or a civilian, is evidencing deliberate premeditation. And I think that's inconsistent with common sense, and I don't think that's a position that can stand. I count 9 inferences stacked on one another throughout this case. It's inference after inference after inference.
Mr. Shaw, what's your best case on the non-support of an inference of premeditation in a gun battle or a shooting case?
Well, as you know, in my brief, I think I've cited something like 20 cases from many jurisdictions. And there's one central case from Massachusetts. It's escaping the name of the case.
I'll find it.
Escaping. Yeah.
I obviously read your
Yeah. There are cases from across the country.
I'm particular in SJC cases.
And an SJC case, which is cited in the brief, in the body of the brief before the footnote occurs.
I'll remind myself.
The name is escaping me. Okay. Now, with respect to ineffective assistance of counsel, the failure to address in any manner whatsoever evidence leading up to the shooting and the government's concession as to causation denuded Mr. Williams of substantial defenses. This isn't a case like Bonnet, where there was no factual basis at all to assert a mitigation defense. And as this court held in—
the tactical decisions.
Right, and as this court held in Bonnet, and I explained in my brief—
It's possible to ride 2 horses, but you don't have to. So
That's true. But again, when you contrast the factual basis in this case as compared to a case like Monnet, this case is crying out mitigation. I mean, if you look at the description of what happened, the prosecutor's opening argument, it describes self-defense. If you look at...
Does the defense attorney have the ability to go all or nothing?
I think that unless it's manifestly unreasonable, and the issue here is that the issue of identification, which he asserted, and the issue of the state of mind of the shooter, whoever that was, are not inconsistent. They're independent, sequential questions.
You can see trial counsel's dilemma there. Either it's in closing, for example, he or she would have to argue, it wasn't my person, it wasn't this defendant, but if it was self-defense.
But I don't think so, Your Honor. I think what you say is that this was not Mr. Williams.
Yes,
it was not Mr. Williams. But whoever it may have been, this evidence doesn't show anything other than self-defense or any of these mitigation defenses. Question one, was it him, jury?
And you think the decision not to make that argument, which I think would be awkward, was manifestly unreasonable?
Well, I think as this court stated in Bonnet that it would have been beneficial, that it wouldn't have been awkward. And the problem is that it deprived the jury of the only legal vehicle.
Just remind me, Bonnet was a holding that defense counsel is ineffective by choosing a lack of identification defense over a self-defense?
It was the exact similar issue. The judge addressed this, whether these are inconsistent defenses, as I believe the judge below ruled, and said that they were not.
And we held that it was ineffective not to ride both horses.
No, no, in that case, you held that it wasn't ineffective. But in that case, we have a situation where the defendant is literally observing other people argue and pulls out a gun and shoots somebody. So it wasn't ineffective in that case. Here, this is entirely different. What happened here is that counsel left the jury without any legal vehicle to address the shooting itself and facts that cried out.
Does the judge have to have a colloquy with the defendant in those situations?
I don't believe so. I don't believe that the law holds that.
Apart from better practice, but there's no requirement, correct?
I don't think so. That's not my recollection of the law. Okay, but again, how was the jury going to address any of this? Facts that completely supported a defensive conduct and was consistent with the government's own theory of causation. So it makes no sense, given the facts of this case, that mitigation defenses were entirely omitted. And without raising any of these issues of mitigation and guiding the jury's analysis with jury instructions on the law, the jury had no means by which to understand and address these issues. Now, with respect to prosecutorial misconduct, this was not a case of overwhelming evidence, and so it was vulnerable to the prosecutor's calculated tactics. After assuring the court and defense counsel that he had no intention of focusing on sympathy and emotion, he began by framing the entire case in those terms, urging the jury to view what happened through an emotional lens and the effect on family members. Analogizing this case to a woman being crushed by a 26-ton slab of concrete was deliberately designed to make tragedy, loss, and importantly, the impact of tragedy and loss the jury's focal point. And even more egregious was the prosecutor's persistent, calculated references to evidence allegedly collected but not presented at trial. And that included repeatedly referring to police having numerous audio and video recorded statements from people identified in a video, one by one, the camera surveillance, using the decision of investigators to charge Williams by emphasizing that they had the statement of Joyce, the statement of Reed, the statement of Williams, and then what did they do? They let Reed and Joyce go, and they charged Williams. This was all to bolster the assertion that Williams was the correct party, the guilty party. Referring to evidence that the jury couldn't hear because of evidentiary rules, using the fact of a grand jury indictment as corroboration that Williams was properly charged. So all of these tactics and their purpose are clear in the trial record. I'm confident you're going to see that when you review it, and serve the intended purpose of prejudicing the jury against Williams in a manner that was improper. And then we have gang innuendo, sworn enemies, stealing the block, an agreement to harm each other, repeated references to the gang unit. And you'll note that after Detective Ford testified that he was with a sergeant from the gang unit, the prosecutor proceeded to elicit that he participated with the sergeant in identifying people on the video known to the police. That's at volume 9, pages 172 to 180. And I wonder what the purpose of that was. I think it's clear. And then finally, we have the prosecutor personally guaranteeing jurors that if they had been there that day, they too would have identified the shooter as wearing green instead of blue. And that was obviously improper vouching. So in a case like this, where we don't have overwhelming evidence, and we have a case that supports panic rather than premeditation, these errors matter. Finally, on the issue of GSR evidence, there are 3 fundamental problems. First, the negative test result for GSR was not probative of the identity of the shooter. It showed that there was a particle, but under the lab's own scientific standard.
Didn't the prosecutor follow our case in Commonwealth versus Johnson?
Well, I don't think...
Which preceded this case?
Excuse me?
Which preceded this case?
Johnson preceded this case. And I think in Johnson, we don't have a prosecutor who's arguing that the jury should, in essence, use a negative result as evidence to convict a defendant.
I thought that's what Judge Cordy wrote in Johnson.
Well, first, in Johnson, the issue was, is GSR junk science or false evidence? And what we had was an expert who testified that the result was negative. And then we had a prosecutor who essentially just simply clarified
Right, so
why that's so.
In Johnson, there was a negative on this, I forget what was the glove or the sweatshirt. There was a sweatshirt and a glove, but there was a negative.
Well, there was also a positive on the same person.
Right. In discussing the negative, the SJC wrote that on one hand, the jury was told that 2 particles were on the sweatshirt, which in light is a permissible inference, increasing the likelihood of the defendant's culpability. The jury was entitled to draw these inferences. The judge didn't abuse his discretion in admitting this negative testimony.
Right, I think that case has been quite problematic for reasons that I'll discuss in a moment. But
it's different but saying to overrule Johnson versus it doesn't comport with Johnson.
I think
those are two different things.
Well, I think Johnson is distinguishable, and Johnson is distinguishable because all we have in Johnson is an expert coming in and testifying it was negative, and the prosecutor confirming why was it negative because it was below the threshold. That was it. We're not talking about that here. And here we're talking about, again, the standard says...
But excuse me, if it was fine per Johnson for it to come in because it had some probative value of making it more likely than not that the person who had the particle shot, wouldn't it have been permissible, therefore, for that prosecutor to argue in closing that inference, that is the whole reason why we found the evidence admissible? Why does it matter that the prosecutor didn't argue for the inference that we said in Johnson was permissible?
Okay, well, first I would distinguish Johnson on the facts because it was a single person, it wasn't a group, and he had another positive result. So I think it's a very different case. But in addition to that, I don't think it would have been permissible for the prosecutor then to forcefully argue and make central to the case the fact that this negative GSR test result is what you should use to convict the defendant, as occurred here. And again, going back to
So they're allowed to have this probative evidence, but they're not allowed to argue it?
well, they're allowed to elicit from an expert that they went ahead and did this test. I mean, that's good police work. The test was negative. Why was it negative? It was negative because it didn't meet a threshold for us saying that it was a positive result.
But we expressly held in Johnson that it was the jury were entitled to rely on that particle, I think it was 2 particles, to say that to draw the inference that it was that it lent weight to the idea that that person had shot the gun.
Well, Johnson did say that it could come in the manner that it came in that case. But again, I just want to point out, and it's very important, because here the issue is, was this probative of who fired that weapon? And the test says, no, we don't meet the threshold for this to be probative. We then have the facts in this case that we know that he disposed of the weapon after the fact at Reed's order. And the amount of these microscopic particles was consistent with secondary transfer. So the question is, how is that even probative at all of somebody firing when we also have a test that says it doesn't meet that threshold? And it's a real problem that I think this court needs to address, because I'm seeing this in case after case after case where the prosecution is using this. And what it does is it invites the jury to speculate. There's no meaningful difference between one more microscopic particle or one fewer microscopic particles to a lay juror. They don't have a basis in knowledge to ascribe some meaningful varying of probative weight to the difference between one microscopic particle.
Well, in fairness, in this case, they do sort of have a comparator in the sense that the other 2 were swabbed and they did not have any GSR residue on them.
And that could have been for any number of reasons. For example, where they swabbed, if these were apparently experienced people, they could have been wiping their arms. I mean, I think the prosecution even sort of addressed that. And so this, I think the court should really address this, because this is a real problem that we have. Our legal process is properly restricting an expert witness from presenting misleading testimony by testifying in a manner that's inconsistent with the scientifically based forensic standard, but then we're allowing a prosecutor to use that same information and here free rein to really forcefully urge, in essence, a standard that is inconsistent with his own expert but favorable to conviction. I mean, the prosecutor is saying, yes, it's a negative test, but you don't need to treat it as negative. I mean, that's in essence what he's saying. And so I think that that's highly improper, and it's a real problem in our cases. Thank you.
Okay. Thank you. Attorney Hartley.
Morning, and may it please the court. Brooke Hartley for the Commonwealth, and with me at council table is Assistant District Attorney Mark Lee, the trial prosecutor in this matter. I would also like to just briefly acknowledge the victim's family member who is here in the courtroom and possible other family members watching on the live stream today. This court should affirm the defendant's convictions and remand the case for a hearing pursuant to Commonwealth v. Mattis for resentencing.
Start with gunshot residue
Sure.
Evidence.
Sure. So what the defendant is urging this court to do in regards to the gunshot residue evidence is essentially overturn Johnson.
Yeah, and I'm wondering why we shouldn't.
Well, so I think what Johnson says and the law of evidence is that gunshot residue particles that were found on the defendant's person doesn't necessarily prove that he committed the murder, but that's not the test of admissibility. The question is relevancy here.
Well, we don't do it with fingerprints or DNA, right? So if we have a partial fingerprint that doesn't match whatever criteria for points, it's a partial, we don't allow that to be argued as that it's inculpatory. If we have DNA test results that doesn't meet a scientific threshold to be a positive, we don't allow the prosecutor to say, well, I know it didn't match the defendant in the rape case, but there was male DNA. So I'm not aware of anything other than Johnson and GSR where we allow this to go to the jury for what it's worth.
So I think it's a little bit
But
different.
Can you think of anything that any other, I'm racking my brain for other forensic testing, and I don't really see one where we allow this type of shorthand.
I can't think of anything akin to this, but I do think that gunshot residue is different than fingerprint or DNA. And what Johnson says is that as long as this is before the jury and the jury understands what the standard is, that
It seemed like in Johnson, the court said, well, it's the unique nature of the particles, the antimony, the barium, and the lead, right?
yes, and I think what Johnson also says is that the jury could draw an inference either way. The jury could draw an inference, well, this was negative and the Commonwealth didn't meet the threshold, so we shouldn't consider it, whether it be because of secondary transfer, which the defendant is certainly entitled to argue and did in this case.
In the other forensic testing that I just mentioned, we don't allow jump balls to go to the jury.
So I think this is different because this is probative. This is probative of who the shooter is. One particle versus three may not reach the standard, but it's still probative, especially as Justice Stewart mentioned in this case, where the other two were also tested and no particles were found. So I think as long as the expert explains what the standards are and does not draw any conclusions themselves connecting the person who is wearing the clothing to the shooting.
Why wouldn't that apply to DNA evidence, right? I guess now I'm going to be dangerous because I don't know enough about DNA evidence. But let's just say an expert got up there and said, you know, these 5 alleles all look the same as the person who committed the robbery. But it's not enough scientifically for me to conclude that. And then the prosecutor comes in and says, well, look, there's a match on 5. It's not enough scientifically, but, you know, between us chickens, we can guess.
Well, because I don't think this is a guess. It's in the DNA world, when you don't have enough, you can't, it's not clear where it came from. Here, we know there were
that
particles.
standard, though, comes from the scientific community. What is enough is what the scientists say is enough to make a conclusion. But if, and here for GSR, the scientists say you need 3, whatever. What is it? Residue?
Gunshot residue particles.
3 particles. But we're allowing the prosecutor to say, well, here there was 1. I mean, in Johnson's turns, like there was 2. It seems like there's a reason why the scientists have come to some conclusion as to what the minimum is that they need in order to make a conclusion, draw a conclusion that the jury can then use to infer he has gunshot residue because he was the shooter.
Sure, I understand Your Honor's question, but in the DNA cases, it's different because we don't get to that conclusion. Here, the conclusion is that these particles are found wherever they were found.
But isn't the whole reason why the FBI has completely abandoned, reportedly, this form of forensic evidence is that the risk of contamination is so high because they are really persistent in the environment? And so, like, there's a risk of lab contamination and so forth. And so isn't that part of the reason why they require 3?
So I don't know the reason behind the requirement of 3. I don't know that that's laid out in Johnson. But I do know that all of the weight of the evidence is a question that goes to the jury.
You do know that the BPD crime lab does not do GSR for that reason, and that's why you have to use Drugan in the Mass State
That is
Police
true.
Crime Lab.
That is true, Your Honor.
So the BPD crime lab has said, we're not going to touch this stuff.
Sure, and I think again, the difference between this and other forensic evidence is that the jury is
And
entitled.
I'm not saying in this case, the Commonwealth seemed to have followed Johnson. I'm not saying that it was wrong in this case. I'm just talking about why we should continue this.
I understand, and I suppose that's a question for this court, but I think that I don't think that this court should overturn Johnson following in line with DNA cases or fingerprint cases, because I do think the conclusion that a particle is found on an article of clothing is different than a partial print or several alleles that aren't enough to match with a person, especially where the jury is entitled to make inferences either way, and the defendant can argue for those inferences, one of them being secondary transfer. It means absolutely nothing. In fact, this is actually detrimental to the Commonwealth's case where they weren't able to.
Was there an objection to the GSR in this case?
I don't believe so. Your Honor, I don't believe so, but I'd have to go back and check that. I
In
apologize.
Johnson, there was no objection to the GSR either, right?
No, there's no objection in Johnson.
How do we overcome the concern that what the closing did was to invite the jury to speculate? Because the actual language used during the closing was to acknowledge that the expert's protocol required that these two particles just be deemed a negative, and then said, that's an expert witness trying to help you understand the concept. That's not your protocol. You can interpret that however way you want. So how is that not inviting the jury to speculate? What if the only evidence they have is that there's a negative test? There's nothing that would allow them to, how would they attach a significance to that other than through speculation? Because there's no evidence regarding its significance apart from the expert's testimony.
So I think first of all, as this court knows, closing arguments are not evidence. And I think where the expert testified very clearly about the standards, the expert responded to the prosecutor's question, which was, it's fair to say that given those findings, your determination for all three individuals was that the gunshot residue testing was negative. Is that correct? Yes. So it's very clear that this did not meet the standard required here.
So when the prosecutor is asking the jury to go in a different direction, use its own protocol, what protocol is that? Is that just, one, and how, I don't know how that's anything other than, fly around however you, go outside the reservation, do whatever you want.
I think the prosecutor's closing was simply arguing that this is probative evidence, which is what Johnson says. So it says that the Commonwealth is entitled to argue that it is probative of who fired the shot. I don't think the language that Your Honor referenced was anything more than a figure of speech, especially where the jury is instructed and reminded that closing arguments aren't evidence.
Can you address evidence of premeditation?
Yes, Your Honor. So in regard to the first issue, the evidence, when considered in the light most favorable to the Commonwealth, was sufficient to establish first-degree murder by deliberate premeditation for three reasons. The first is that intent can be formed in a matter of seconds, and the jury could have inferred as much here. The second is that this was a shootout, despite the fact that Colas didn't get a shot off, and deliberate premeditation in that context is a little bit different. And the third is that this conflict began before Colas raised his gun and aimed at the defendant and his friends. And there's a reasonable inference based on the record that the defendant became part of this conflict.
Well, he showed up. So can you just go through your inferences more slowly with respect to the evidence that the inferences are based on? So the first one, you said premeditation requires only a couple of seconds. Of course, that's a lot. So, but you can't just state that and say that therefore there's sufficient.
I was just trying to outline an argument and fully intend to go through the evidence, Your Honor.
In case you might not have time to get to it all.
Yes, I just wanted to make sure I got it all out first. Okay, so in regard to intent being formed in a matter of seconds, first, there were 5 shots. The reasonable inference was that there was 5 shots fired here. Brenda Robinson testified that there were a lot of shots. Amanda Griffith testified she heard 5 shots. There was a revolver recovered from the scene with 6 spent casings. And there was testimony about how firing a revolver to get 6 spent casings, you need to pull the trigger 6 times. There's also the fact that this was a shooting that took place in relatively close proximity, less than 100 feet. The next piece of evidence that supports this this intent being formed in a matter of seconds is Brendan Robinson hearing Williams, someone from the defendant's group, jumping up and down. And I know the defendant argues that this should be an inference taken the opposite way, but I think it supports deliberate premeditation formed quickly, jumping up and down, saying, blast them, suggesting that this wasn't just a reaction to Colas pointing his gun. And finally, there's the inference that the defendant brought a loaded firearm to this conflict. Now, we know that based on the fact that he wasn't present
Can I
in the
just
store.
ask about the premeditation and the number of shots? Do we have cases that say if you shoot many, many, many times, that means the whole thing was premeditated?
So we have cases that talk about how one consideration in favor of premeditation rather than spontaneity is whether the defendant inflicted a single blow. And so I think that
What kind of firearm was this?
this was a revolver.
And the blast then preceded the shooting.
Preceded the shooting, yes. And in regard to the inference that the defendant brought a loaded firearm to this conflict, this is a reasonable inference based on the fact, one, we know he wasn't present in the store. He's not on the camera. And we know that a witness, Amanda Griffith, places a firearm in his hand at the time of the shooting. And we also know that the jury found him guilty and found that he fired the shots that killed one person and injured a second person.
That's not evidence.
No, but I think that's the inference. That's what, in order for the jury to get there, from the fact that he wasn't there, from Amanda Griffith's testimony, that's the inference they made. So that I think that's a reasonable inference that this court could make based on the evidence that I just listed. Now,
Was the jumping up and down and statement blast them, did that precede Colas pulling out the gun?
yes, I think the record shows that it did precede. Well, I'm sorry, I don't know. No, I think it precedes obviously precedes the shots being
the
fired.
shots being fired, but I didn't see that it preceded Colas pulling out his gun.
I'm not sure the record is clear on that point. I think the reasonable inference that the jury could have made is that it all happened very fast. I don't disagree with defendant's representation of how fast this entire conflict happened. And I think, if anything, that supports the Commonwealth's argument about intent and deliberate premeditation.
I forget, where was this witness positioned?
Where was Amanda Griffith positioned? I believe she was coming from walking towards McClellan Street. So she was walking in the opposite direction that the shooter and Tevin and Colas were walking. And she observed this happen at I think the corner of Blue Hill and McClellan. Now, my second point, that this was a shootout despite Colas not getting a shot off, the jury could have found that based on the fact that the events happened in immediate succession. If you look at Troy Soto's testimony, it was his grand jury testimony that was ultimately read into the record at trial. Excuse me. He testified that as soon as he pulled the gun out, meaning the prosecutor asked, as soon as he pulled the gun out, did something happen? And Soto said, the shots rang out and he ran. He also described Colas as the one that didn't get a chance to shoot. So I think Santiago is instructive here. Santiago essentially says that it doesn't matter who fired first in the case of a shootout, which in turn means that the defendant chose to engage in this shootout and can be held responsible.
Did the judge give a Santiago instruction?
Yes. And obviously there's no question here that the defendant is the cause of the victim's death, but Santiago is still relevant to premeditation in this case. You have engaging in a shootout, which is different than being reactive to someone firing a gun, is sufficient to show premeditation. And
That Santiago instruction was causation.
so, that was in regard to Colas. So yes, he gave the instruction. I think you're right, Your Honor, in regard to causation. But I think it's still relevant to deliberate premeditation, and I'll explain why. So, and it's because of that engaging in a shootout is different than being reactive to someone firing a gun. And
Well, hold on. It can be, right? I mean, I think the defendant makes an argument that on the basis of your argument, anyone who fires a gun, who has a gun and fires it in self-defense, has engaged in a shootout and has and premeditated the killing, which obviously can't be the law. So what are the facts that distinguish this situation from that argument?
Sure. I think it's the totality of what I am currently in the process of going through before the court. So it's not only the fact that the deliberate premeditation, the intent can be formed in a matter of seconds, but it's the quick sequence of events here. It's also, I think the defendant seeks to distinguish this from Santiago because the defendant didn't leave to retrieve a gun here. Now, that's certainly a factor that would contribute to a finding that the defendant.
Aren't most self-defense cases premeditated? There's a perceived threat. This person's coming at me with a knife. I better shoot this person.
I think that is different than
That means it's a lawful killing, but it's still premeditated, right? But it's an excused killing.
Well, I not necessarily, Your Honor. I don't think so. I think this is a case where you have, no matter how short the period is, you have a period of deliberate reflection and premeditation. I don't think you necessarily have that in self-defense cases or in reasonable provocation cases where it's all about spontaneity.
Provocation is different than self-defense.
Yes, yes.
As far as spontaneity.
I would also note, Your Honor, when considering in the light most favorable to the Commonwealth, and I think Justice Wolohojian briefly addressed this when defense counsel was arguing, but where mitigation was not before the jury, it's not really relevant here. It certainly goes to how the jury should have been instructed, and it's properly raised as an ineffective assistance of counsel claim. It's something this court can look at on 33E. But when considering sufficiency to require the Commonwealth on appeal to disprove self-defense or reasonable provocation when it wasn't before the jury at trial goes too far.
But going to the I take your point, but going to the premeditation point, it's a really difficult fact for the Commonwealth here that it seems to be undisputed in the record that the Reed group, as it were, walked away from the store, right? They walked away and Colas came behind them. And I don't understand that to be disputed in the record, right? And then Colas raises the gun, and that doesn't seem to be disputed that was the first in the record aggressive act. And so clearly the Reed group then ascertains that a gun is raised and they respond. And it's obviously, the defendant is going to have been convicted of being the person who responded. So can you address that point about the fact that this is, if you wanted to make if your whole theory is this is a deliberate gun battle, a duel, that kind of situation, you wouldn't expect that to start with one group walking away.
Mm-hmm. Yes, Your Honor. So I think, again, when you take everything in context, they were walking away, but there's also what happened before. And there's also the fact that the defendant inferentially was on scene with the loaded firearm fired almost immediately after Colas raised his gun, suggesting that these two were ready to engage in a gunfight. And I would also note that if you look at this court's opinion in Colas, obviously Colas is a completely different case, and I can explain that in regards to 33E review, where the court found that he didn't have the lethal intent required for deliberate premeditation, first-degree murder. I think the court did accept that this was a shootout. And I know Justice Gaziano wrote the opinion, but the court said in Colas that even where Colas did not fire, they recognized that this was a close call in regards to sufficiency.
It was reversed because of the instructional error about an inference, not on sufficiency.
No, and I'm just saying that the facts are the same for both of these cases. And the court, Your Honor, and the court there accepted that this was a shootout based on those facts. And yes, it was reversed for completely different reasons that aren't relevant to this case. But I think it is relevant that in Colas, this court accepted that this was a Santiago-like shootout.
Do you concede that the defendant would have had the ability or would have gotten instruction on self-defense and or provocation?
Would have gotten
If asked, that it would have an instruction would have been warranted on self-defense and or provocation.
If asked, I think the judge would have been required to if asked.
So you concede that?
Yes. But again, I disagree with my brother's reading of Bonnet. I think what Bonnet says is...
The question then becomes whether it was ineffective assistance not to ask for, correct?
Which I think it was not, because, and I can address that, but the decision to argue that the defendant was not a shooter rather than assert a theory of self-defense was certainly a reasonable tactical decision on this record. First of all, any acknowledge any argument regarding self-defense or reasonable provocation would require some acknowledgement that the defendant was the shooter. And Bonnet recognized, even if this court says, well, it wasn't him, but whoever it was reasonable provocation or self-defense. Bonnet said that can still undercut that all or nothing defense and is a reasonable tactical decision. I would also note that as defense counsel mentioned in the beginning of his argument, this is a case where the defendant wasn't identified. He wasn't on the video. So it was not a far-fetched argument to make before the jury. And it was most certainly not an unreasonable tactical decision, even if it didn't play out the way the defendant had hoped at the time. If the court does the court have any further questions in regards to the closing or any of the other issues raised by my brother?
We're all set.
Okay, I would just end by saying that I think the defendant's argument, especially in regard to sufficiency, reads much like a closing argument to the new jury. But this trial jury heard all the evidence, even the conflicting evidence, saw the videos, and weighed the credibility of witnesses who placed the gun in the defendant's hand. So there is no basis to disturb this verdict. Thank you, Your Honors.